He's a part head of sales in the Masters of Commercial and Interregional Card Claims Ltd and Mastercard and others.
Very good morning to you, Lord. There's a new piece of paper which we've placed before you, which I'll turn to shortly.
Yeah.
But I brought it to the court's attention because the focus of allowed defence submissions yesterday was to 2009, and that being so, the consultation in 2009, we will see, greatly assist the court in understanding what the government understood by reference to the then existing landscape in relation to CFAs and DBAs. But I'll come to it in a moment if I may. Just before doing so, I wanted to just finish.
This is a consultation paper.
It's consultation paper.
I'm going to get technical. Is it admissible?
It is admissible.
Consultation papers are, of course, not the end result of a
They're not.
consultation.
And
it can be. There is, I think Quinterval says it can
Quinterval says it can be. They've been referred to in other, consultation papers have been referred to in other related funding cases. We don't have the government's conclusions, but I don't need to go to the government's conclusions because I go to the structure of the Act once it's finally promulgated in 2009 with section 58(1).
I understand that. All I'm saying is that the consultation paper presupposes that the MOJ had an open mind and was just putting out issues,
Yes.
not expressing a view, otherwise it would be an unlawful consultation.
And then there'll be consultation and the end result might be something different.
Yes, but the importance, we'll see, the relevance of the document is the government's then, the MOJ's then understanding as to what it created by way of CFAs and the distinction between CFAs and what it was intending to create by way of DBAs. That's the purpose of it.
Okay.
And the particular focus is on percentages.
Okay.
All right. Okay.
So it's factual background.
It is.
You wanted to give us something else first.
I do, and that's just to finish off the construction, the statutory construction rules, if we can call them that I took you to in relation to PACAR. I wanted to refer to the Hertfordshire case. It's at tab 21 of the authorities bundle.
Yeah. Tab 21.
Tab 21.
That's volume 3, is it?
Volume 3, I believe. I've got 2 volumes of the authorities bundle. It should be.
Yeah.
Tab 21.
Tab 21.
And it's a decision which considers the decision then of Mr. Justice Leggett as it then was in R&N. These are, I'm sure, familiar principles, but they're important in this case. And just before I take you to it, this is in response to the submission that the court is not committed to look at what goes on in 2012 and 2013 in seeking to interpret what goes on in 2009, which is what the Learned Friends submissions broadly are. And just so you have it, we say that you can determine what the Parliament meant by the words used in section 58AA in 2009 without actually referring to the subsequent legislation. But if you do refer to the subsequent legislation, it's completely consistent with how the government understood the position to be in 2009. That's our submission. So this authority, it's a quite interesting case about what a meeting is in the pre-COVID world, where the meetings had to be in person or could be remote. And in paragraph 68 of the judgment, this court, the Court of Appeal, Dame Victoria Sharp,
It's a
referred
divisional
to.
court, isn't it?
It is indeed referred to. It's a divisional court. Referred to the R&N decision. A useful starting point, setting out the principles to apply to the construction of the 1972 Act. Quote, on analysis, the conflict between the historical approach and the updating approach to statutory interpretation is not as deep as may at first appear. Treating legislation as, quote, always speaking, can still be seen as an exercise in identifying the meaning of the legislation at the time when it was made. It is just that this meaning is one which allows the relevant statutory language to have a changing application. 69, in considering whether Parliament intended an updating construction to be applied, it's appropriate to consider matters such as the generality of the language used, but in each case where relevant circumstances change since the legislation was enacted, it is a question of interpretation, whether it is reasonable to attribute to the legislature the intention that the words used should be interpreted and applied in a way which takes account of that change. And at paragraph 70, the court refers to Mr. Justice Leggett's decision at paragraphs 53 and 54, noting that, quote, Parliament can change the meaning of an existing statutory provision, either directly or by enacting a general rule of interpretation, such as occurred with the enactment of the Interpretation Act 1978 and with Section 3 of the Human Rights Act 1998. He then said at 55, even without explicitly requiring the courts to give a term an existing legislation or a particular meaning, or to apply a specified rule when interpreting the term, Parliament may act in a way which treats the term as having a particular meaning and signals its approval of that meaning. The signal is important. And having given examples at 71, applying the reflecting this principle, Justice Leggett continued, this approach seems to me to respect the constitutional principle of parliamentary sovereignty. As the passage at Benyon quotes a statement of Thomas Hobbes in Leviathan, that the legislator is not he by whose authority the laws were first made, but by whose authority they now continue to be laws. If Parliament had proceeded on the basis that an existing law has a particular meaning at a time when, if Parliament had understood the law to have a different meaning, it is reasonable to infer that it would have acted. That may properly be treated as an implied directive as to how a previously ambiguous law should be interpreted. Now, applying those principles to this case, just assuming that in 2009 one can't divine the proper, appropriate, purposive meaning of the words determined by reference to the specified financial benefit in 58 AA 3A2 when it was first introduced. We submit you can certainly have reference to what happened in 2012 with the introduction through LASPO of the amendments to Section 58, expanding damages-based agreements to all civil proceedings. And at the same time, Parliament's decision to impose statutory requirements limiting or capping the sums that could be paid in respect of CFAs, where CFA arrangements are incepted. Because my learned friend's case is that, in a nutshell, that any arrangement under which the lawyer or claims manager limits the fees that they charge by reference to the proceeds, you create a damages-based agreement. He says that in terms, that's what his case is. And he says that's the effect of the meaning of the words, properly interpreted, of the words determined by reference to the specified financial benefit. Now that simply can't be what Parliament meant in 2009, because in 2012, Parliament was expressly recognising, in fact requiring, solicitors or those undertaking, providing litigation services, so it include barristers, entering into CFAs to cap the amount that they can charge by reference to the proceeds. If the learned friend were right, Parliament was legislating to require caps in one stream of litigation funding agreement, but at the same time rendering that stream of litigation funding agreement a DBA, which is a separate form of litigation funding agreement. And that, with respect, is a wholly incoherent, implausible outcome which doesn't bear proper scrutiny on any analysis and therefore speaks strongly against the interpretation which my learned friend seeks to impose on those words in 2009. In fact, the argument is equally deployable in relation to what was known in 2009, because in 2009 we have these two streams of separate funding arrangements. So just before departing from this authority, at paragraph 73, there's a reference to the Benyon, Bailey and Norbury statutory interpretation, where it's said in quotes, where the legal meaning of an enactment is doubtful, subsequent legislation on the same subject may be relied on as persuasive authority as to its meaning. And that was the purpose of my submissions yesterday, the same subject matter, paragraph 73. Parliament in 2012 and 2013 was dealing with the same subject matter as Parliament was dealing with, it's obvious, in 2009, and therefore it's perfectly permissible to have regard to the subsequent legislation, the 2012-2013 legislation, in seeking to understand what Parliament understood to be the position in 2009. That takes me neatly on to my next series of submissions, which really seek to focus on ensuring the court understands the history, just to help with the history and the chronology, because, as I say, my learned friend's case is that you should start from 2009, but you don't. There's a very helpful summary that Sir Henry Brooke gave in Hollins and Russell, which is in the authorities bundle. I'll just remind myself of it's at tab 8, so it's the earlier authorities bundle, file 1. It will be, I'm sure, useful for the court as a helpful reminder of what was going on prior to 2009 and subsequent to 2009.
Yeah.
Because my lord is slightly handicapped in the sense that we've focused on statutory instruments in 2012 and 2013 and in 2000, but we haven't focused on what was going on before 2009. And in the light of my learned friend's submissions, I'd like to just sort of close that gap off. And at paragraph, really the introductory paragraphs, paragraphs 1 of the judgments, Lord Justice Brooke set out a helpful sort of history of the legislation going back to 1988. It's page 289 of the bundle. And it's the history behind section 58 of the Courts and Legal Services Act, which is referred to in paragraph 2. Section 58, we see in paragraph letter E. Of that Act, Parliament decided to permit conditional fee agreements in relation to the provision of advocacy or litigation services in highly prescribed circumstances. And it provided, section 58 was an enabling machinery. It was brought into force in July 1993. You see that in paragraph 3. And 2 years later, through the introduction of the Conditional Fee Agreements Order in 1995, CFAs became lawful for the first time. And they could only be made in connection with one or other of 6 different types of litigation, which were proceedings, which were referred to in Article 2. And they were, broadly speaking, personal injury cases, my lords, and some insolvency related litigation. So they were limited at that stage. And you'll recall from your own experience that this was all brought into force in the light of the problems over legal aid and access to justice. Now, the paragraph 5 then refers to the 1995 regulations, and we don't have them in the bundle, but they're here referred to quite helpfully. In short, by Regulation 3, a lawful CFA had to be in writing and state the particular proceedings or part of them to which it relates, the circumstances in which the legal representative's fees and expenses are payable. And over the page, if you go down to the last sentence of that indented paragraph, in particular, whether or not the amount payable is limited by reference to the amount of any damages which may be recovered on behalf of the client. So, in 1995, solicitors undertaking conditional fee agreement work were under a statutory obligation to state whether or not the charges that they were levying, their primary contractual entitlement, namely their hourly rate multiplied by time spent under a CFA, was in any way limited by reference to the damages. That requirement continued and found its way into the 2000 regulations, as we shall see in a moment. The 1998 Conditional Fee Agreements Order is referred to in paragraph 8 of the judgment, which extended CFAs to all proceedings other than criminal proceedings. So it opened up CFAs to cases beyond just personal injury cases. And so I am able to make the submission that by the time that the 2009 amendments were made, introducing DBAs, that there was a recognised position that CFAs were agreements under which the solicitors were able to limit the amount that they charge by reference to the damages. And as soon as you end up in that world, it's an impossibility to then interpret the words determined by reference to the damages in section 58AA as meaning what my learned friend says they mean, because you become entangled into an unfathomable mess, frankly. Going on from the 1998 order, can I then pick up at paragraph 15? The government, the Lord Chancellor, the Access to Justice Act of 1999, but we're at paragraph 17 of Sir Henry Brooke's judgment. The method by which Parliament chose to proceed was by repealing section 58 of the 1990 Act and substituting two new sections, 58A and 58. So they both cover CFAs, but they were introduced with a view to enabling the recovery then of the success fees in proceedings. Alongside the introduction of those new provisions in the Courts Legal Services Act, the government introduced regulations, and they were the Conditional Fee Agreement Regulations 2000, which are referred to in the judgment at paragraph 30. They're referred to in that paragraph as the 2000 regulations, and at the same time the Conditional Fee Agreements Order 2000 was also made, which brought into effect sections 27 and 30 of the Access to Justice Act, which dealt with the recovery of ability to recover success fees. Now, you'll see at paragraph 31, Regulation 2 is very similar to Regulation 3 of the 1995 regulation. It requires the CFA to specify various matters, including by Regulation 2.1d, the amounts which are payable in all the circumstances. I'm now reading from page 295, letter E to F. The amounts which are payable in all the circumstances in cases specified, or methods to be used to calculate them, in particular, where the amounts are limited by reference to damages may be recovered on behalf of the client. So it was again respecting the position that solicitors were able to, and if they were to do so, they were required to state that they were limiting their primary contractual entitlement, namely an hourly rate by reference to time spent, by reference to the damages. And there were separate provisions in relation to success fees. Success fees were introduced to enable a solicitor to claim a multiple of their fees, namely 100%.
Yeah.
But Parliament does not permit, and did not permit then, the solicitor to charge more than that by way of multiple. one other absurdity, because there are many, but one other absurdity I submit of my learned friend's submissions is that if he's right about his interpretation of the meaning of the word determined by reference to the specified financial benefit, we end up in a world where a solicitor can charge a multiple in excess of the twice basic charges, let's say 7 times, add a proviso saying, but I'll limit it to the sums recovered in the proceedings, and create a DBA. Solicitors can only charge a multiple by reference to the CFA legislation. They can charge a percentage of the recoveries by way of a DBA. And I'll come on to the percentage point in a moment, because I will be inviting my lords to conclude in the final analysis that DBAs are percentage-based agreements. There is ample authority for that.
We've obviously got the explanatory notes to LASPO, which we looked at yesterday.
We have. I'm going to come to, yes.
But I mean, there are other materials that support that submission as well, are there?
Indeed. So on that material, can I first then, I've got to the point where we've got through the CFA legislation, the new regulations in 2000. We're coming up to 2009, which is the Coroners and Justice Act, where the DBAs were introduced. In advance of that, the consultation paper regulating damages-based agreements was published in July, 1st of July 2009.
You do have an electronic copy of it that you could email at some point?
We can certainly, yes. Yes, apologies for the paper. I know that's a perfectly justified bugbear. The relevance of the paper, my lords, is, as I'd indicated, to help with the factual background, which I hope will assist your lordships in future judgment writing. And it helpfully sets out the background and the approach that the government has taken to terminology, which is actually quite important in all of this. In paragraph 8 I'll just get my laptop version before I go to paragraph 8. Paragraph 2, first of all, please. A clear statement in paragraph 2 that DBAs should be distinguished from conditional fee agreements. Which, as I say, is not respected if my learned friend is right in his interpretation of section 58 AA 3A2. And if you look at just in the paragraph above, the fee, there's a reference to arrangements for receiving a contingent upon success. The fee is payable only if the claim is successful, and then is calculated by reference to damages. That's the penultimate sentence of paragraph 1.
Yeah.
These agreements will be referred to in this paper as damages-based agreements.
They refer in paragraph 3 to the fact that they've been common in employment for
Correct.
some time.
If you exchange the word calculated for determined.
Yes, that's my submission. In fact, I noted in the course of a learned friend submission that either unwittingly or wittingly he used the word calculation at one point. It's by no means definitive, but it is by any means. But I do say that the word determined really means calculated by. We'll see that in both the jurisprudence and also in the consultation papers and explanatory memoranda. Paragraph 8.
Well, that's the point, isn't it, really?
Yes.
I mean, the point is this consultation says that CFAs are not
DBAs.
enforceable. But your point is that if the appellants are right, then applying their logic, they would be.
Yes, indeed.
And this says only that CFAs are not, even though they are calculated by reference to a portfolio of factors which includes the damages.
Yes, quite so.
Sorry, forgive me, I maybe misheard, my lord. Does
You're
this-
referring to DBAs not being lawful
Yes.
at that time, yeah.
Yes, yes.
Yeah, I understood that to be the question.
Yes, sorry, yes.
So you're going to.
Which is why I paused in answering, but I agree with what my lord was saying in the context of DBAs.
Paragraph 8.
The paragraph 17, under the heading damages-based agreements, says the key feature of
This is clearly drawing a distinction, isn't it, between
Yeah,
CFAs where there's an uplift and damage-based agreement which are effectively percentage-based.
percentage effective. That's the point that I'm seeking to develop here,
They're both calculated by reference.
and calculated by reference to. Yes, and you get another place, paragraph 17.
Yeah.
The key feature of DBA is that the persons using the agreements are not paid fees if they lose a case, but are paid a percentage of the damages recovered if they win. Percentage of the damages. And there's a little footnote, 9. These agreements could also be structured so that the fees are calculated, the use of the word calculated, by reference to certain financial awards, e.g. in the case of reinstatement by reference to a percentage of the client's salary on reinstatement. We see in the early incarnations of various of the explanatory memorandum the use of the word usually, percentages. And speaking on this side, we submit that that's probably a reflection of the way in which it was put by the government in paragraph 17. What we see ultimately is the explanatory memorandum, which we'll see, firming up the point that it's actually percentage without qualification. And we'll see I'll take you to it later, but just so you have it, in the final analysis, in the context of the Competition Appeal Tribunal, the tribunal introduces rules which are obviously statutory based, which define a DBA by reference to what is said to be, in essence, a percentage-based agreement. Just draw your attention to paragraph 18, who uses DBAs, that's solicitors and then claims management businesses. We touched on this a little yesterday. Section 59 of the Solicitors Act prohibits the solicitors from entering into contingency fee agreements, which is in relation to contentious business. That was obviously back before 58AA was introduced. It's quite interesting that the Solicitors' Conduct Rules in 2007 then defined a contingency fee, quote, as any sum, whether fixed or calculated, as a percentage of the proceeds or otherwise. And that's how solicitors and the legal market understood contingency fees to be. They're sums of money that are charged.
So at this stage,
At this stage,
could only use DBA, what's a DBA?
what would be a DBA in non-contentious
in
business?
a tribunal,
Correct.
employment tribunal cases.
Yeah, correct. And
Well, actually other tribunals as well.
yeah, and in fact, looking at the sort of multiple point, a solicitor could, in non-contentious business, potentially enter into a multiple agreement. It's all regulated because under the Solicitors Act, you've got to establish that your funding agreement, your fee agreement, is fair and reasonable. Because one of the points I'm dealing with almost at the same time as we go through this is this opening gambit by my learned friend that there are going to be gaping wounds, or you should be careful to ensure there are no gaping wounds in the employment world. There's a sort of threat laid down before my lords, but it's a completely unmeritorious, with respect to him, point to make. I'll develop the submissions as I go along, but just so you have them. In the employment world, services in respect of employment tribunals by claims managers are regulated. They are a regulated service under the scope order. The amount of the fees are not regulated, but the FCA has a statutory jurisdiction to regulate those fees. Leonard was giving these examples of we all being, the court should be concerned that it shouldn't open the floodgates to enable claims managers to claim, 15 times multiples or over generous multiples. It's unthinkable. It's not a helpful example to posit before the court.
Yeah.
Circumstances where that won't happen. There's another reference to, in 23, the need to regulate, going back to the paper.
Yeah.
There was research carried out. And again, there's a clear focus on the last sentence. There are particular issues around the charging of VAT and disbursements. These are the issues that the government was seeking to grapple with in relation to tribunal work that required the intervention. And again, there's a reference to VAT and disbursements charged on win or lose on top of percentage fees. That is how it's understood in 2009 that the DBAs were operating.
Yeah.
Again, for background purposes, so you have it in paragraph 36. The government refers, as indeed does Lord Justice Brooke in his survey of the litigation landscape. When CFAs were introduced, the solicitors, the Law Society, and the solicitors undertaking this work accepted there should be a voluntary cap to what they could charge. This was before the access to justice reforms. The client was responsible for paying the uplift or the success fee, which ultimately came out of the damages. And to ensure that the client's damages were protected, the Law Society recommended a voluntary cap of 25%, so the success fee was capped by reference to the damages. And that's and as Mr. Saul reminds me, that as a standard position was that these fees were always paid out of damages, and that we shall see what happens. That voluntary cap eventually is adopted by the government when it introduces the amendments in 2012. We have we'll see that in a moment. But again, it's all speaking to my point. It's possibly repetitive, and I hope not unhelpful for being so, but it speaks to the point that in 2009, Parliament was legislating on the basis that the existing then regime was two-pronged, with CFAs and DBAs, both entirely separate, with the CFA regime respecting lawyers, solicitors were able to, and in fact should, limit their charges by reference to the damages.
Going back to the percentage point, both paragraphs 37 and 38 seem to me to be predicated upon DBAs being calculated by reference to a percentage of damages. And what they're talking about here is the need to regulate because of the inconsistency in approaches to what the percentage was.
Absolutely.
And hence the point about imposing what was then a voluntary cap, that then in due course becomes a
statutory cap, was yours to see.
statutory cap.
And my lord is absolutely right. 37 is really helpful because it's a discussion about how things may develop and the examples given. It's recognised that DBAs can be structured in various ways. with a variable percentage of damages.
But they're always talking about percentage,
Always.
not talking about anything else.
Exactly, the percentage could vary, for example, it's always about percentages.
So it's not talking about outlay at all.
So that's, and then at the back of the, just so you have at the back of the consultations, you have the draft bill, which is the Coroners and Justice Bill, and that then becomes the Act, as we've seen, as well in the friends
Yeah.
hopefully taken you to already. Now, we say that subsequent parliamentary intervention has constantly respected this distinction that I've outlined between CFAs and DBAs. And what happens is you get to the Jackson reform, so the 2009 Act comes into force. We have DBAs in their limited form in employment tribunals. The government then, because at the same time it's consulting behind the scenes as to whether or not to extend DBAs to all proceedings, as that paper identifies. That work was undertaken by Sir Rupert Jackson. That resulted in various recommendations. You have the consultation in November 2010 at pages 1255 and 1331, just for your note. And then you get the 2010 regulations. And before I come, the 2013 regulations. Now, before I come to the regulations, we have in the supplemental bundle, at page 165, the letter from Lord McNally, which I'd like to refer you to. So the supplemental authorities bundle.
Was he Solicitor General at the time?
Minister of State.
He was a Minister of State.
Minister of State.
Very junior.
So we have now got to 2013 in the chronology. The damages-based agreements 2010 are in place in relation to the employment world. LASPO has been introduced in the light of recommendations by Sir Rupert Jackson, extending DBAs to the wider world. Regulations are required because Section 58 says that's how we're going to manage DBAs through subordinate legislation. In advance of the...
So the position, just so understand,
Yes.
LASPO has been passed, but it hasn't come into...
Correct.
He says it's going to come into force in April. Okay. So what do we get from this letter, Mr. Bacon?
Just bear with me a second, I'm just going to take you to a... Yes, it's LASPO was introduced section 45, damages-based agreements,
Yeah.
removing the reference to employment matters so that it became operable in all matters. Now, in against that background, on the 5th of March 2013,
Oh, yeah.
on the 5th of March 2013, there'd obviously been a useful debate about the draft conditional fee agreements order 2013, which I'll come to in a moment, and the draft damages-based agreements regulations in the Grand Committee on the 26th of February. you'll see at the bottom of the page that both instruments have been subject to statutory consultation in October 2012. And the usual suspects, I put it that way, have been all consulted and needed to implement reforms on CFAs and DBAs when Part 2 of LASPO comes into force on the 1st of April. And under the heading third-party litigation, top of page 167, the matter was debated at some length during the passage of the LASPO Act through Parliament. Some colleagues were concerned about the future growth of third-party litigation funding arrangements, and in particular a move into personal injury claims. While there was a call for the introduction of statutory regulation.
I mean, sorry, just before we get on to that, I mean, the previous section is quite important, isn't it? The class actions use of DBA.
It is.
Because they highlight the concerns raised in the US about speculative actions, and then say the government announced on 29th January 2013 it would prohibit the use of DBAs in collective actions cases in the CAT.
Correct.
So that's presumably the source of what became
The 2015,
7C
in 2015. Correct.
2015.
So the concern about speculative actions were speculative actions outside the realm of competition.
Sorry, my lord.
The concern about speculative actions
Yes.
and DBAs was their extension beyond competition.
Yes.
That might be something Mr. Pitchin is shaking his head vigorously.
But the point is that in 2015,
Well, the first sentence of that second paragraph is seems to be directed at class actions generally,
as they exist in the US.
as
Yes.
a sort of at this stage of the history when there was limited scope for class actions, and then the second sentence is specifically about the CAT, which is
It is.
so there's a slight sort of inconsistency there.
But what happens in 2015 is the government does, through the introduction of Section 47C(8), does prohibit the use of DBAs in group class actions in the CAT,
Or opt out.
in opt-out only.
Well, that's presumably because opt-in give you a choice.
Exactly so, and I'm going to come to opt-in shortly.
Yeah.
I mean, there are lots of references to percentage caps in this letter too, but I was just referring, my lords, to the heading third-party litigation funders. It's I mean, it adds to the mix because we are where we are with PACCAR, except that subject to everything we say our skeleton about whatever may be the future. It's perfectly clear from this letter that whilst there was a call for the introduction of statutory regulation, the government did not believe that it was the right course to take at this stage. And it was an issue that needed to be kept under review and would do so in the future if the need arises.
Yeah.
Now we are where we are with this. The Supreme Court has held that litigation funders were captured by the amendments introduced by the DBA legislation.
Yeah.
So that's that letter. That's in 2013. Can I also then turning to the CFA order, which you have in the, just to make good the amendments that were made in the first volume of the authorities bundle.
Yeah.
Tab 11.
11.
is the conditional fee agreements, tab 11 of the authorities bundle,
That's coming in a second.
page 77.
Oh, yes, sorry, yes. Okay. Yeah.
This is the order that was introduced at the same time that the government was introducing the DBA regulations. So the point being, it's respecting the two separate lines of funding agreements. And it identified personal injury claims as being specified for the purpose of section 58(4)(a) of the Act. And it imposed limitations on the success fees that could be charged at first instance at 25% of the damages. Because the way it works is the order refers to prescribed percentage for the purpose of section 58(4)(b)(c). If you turn to section 58 as it is in the bundle,
Which is where?
which is at page 27. So you'll see that 58AA subsection 4, the agreement must be in writing and then must not relate to proceedings by virtue of 58(1) and 2 cannot be the subject of enforceable CFA or to proceedings of a description. If regulations so provide, must not provide for a payment above a prescribed amount or for a payment above an amount calculated in the prescribed manner. And regulations to be made by the Lord Chancellor in relation to different descriptions under 5. So-
I'm sorry, Mr. I'm getting in wrong. You showed us regulation 4 of the conditional fee agreements order, which is not related to section 58AA, it's related to section 58.
It
You're
is.
showing us section 58AA,
Yes.
which talks about prescribing. That's a different thing on regulation.
No, sorry, it's my fault. It's page 9. Page 9 of the bundle. I'm totally sorry. The point I'm trying to make is that the CFA legislation 58 was amended with 4A being introduced at page 9. At the same time, the DBA legislation was amended to impose separate caps in relation to the damages-based agreement agreements in 58AA. So if you see at page 9, you see 4A being inserted to the section 58(1), which permits for success fees to be limited by prescribed amounts.
Sorry, what are the, it's no doubt my ignorance, but section 58A, not double A, but A,
Yes,
that
that deals with
deals with what?
the supplemental, you see that at page 10, that supplemental provisions relating to the types of proceedings which can be the subject of enforceable
Yes.
conditional fee agreements. They were extended because
So when you look at, you showed us 58 double A, DBA, the DBA
yeah,
section, subsection 4, where
that
it says must not relate to proceedings which by virtue of section 58A 1 and 2 cannot be subject to the enforceable conditional fee.
they're tied in
agreement.
together.
That is criminal proceedings and family proceedings.
Correct.
Yeah, okay, thank you.
The,
It's a shame they couldn't just say that, really.
yeah, the point is that the CFA, what happened in 2013 was significant because the government was introducing statutory regulation of success fees under CFAs through the amendment to section 58(1). That's the amendment that introduced 4A,
Yes.
which was introduced by LASPO, which imposed conditions or additional conditions that the agreement may provide for maximum limits as to what could be charged by way of success fees, described at page 9 as the maximum limit must be expressed as a percentage of the descriptions of damages awarded. And at the same time, introduced damages-based agreement regulations pursuant to section 58AA, which introduced statutory caps on what can be charged. That's the point of my submission. And again, it just reinforces the fact that in 2012 and 13, Parliament must have been proceeding on the basis that these are two separate, entirely separate streams of funding arrangements. One can't be the other. And the other point to make about all of this is as a sort of almost inherent starting point that it's the damages that are utilised to discharge the liabilities. I know that's a simple point, but it's an important one when you come to interpret what section 58AA 3A2 means.
Does this, just trying to factor this analysis into the statutory wording,
Yeah.
so it either goes into the broad expression in first line of 58AA3A, a damages-based agreement, and or it goes to what is to be understood by, is to be determined by reference to.
Throughout. Yes.
This is the hue or colour which you add to one or both of those phrases.
Indeed you do.
Is there anything else in the statutory provision to which this analysis goes? Any other words?
They're the key points because the reference to payment is a new ingredient. The point that we seek to make is that the words determined by reference to the amount of the financial benefit cannot be taken to mean any agreement where you're capping or limiting the sum that's being charged to the damages or proceeds.
But that can also,
It can't by definition because you end up with the cross-fertilisation.
and that can also flow from an analysis of the expression damages-based agreement in context.
Yes, it can. It's a damages-based agreement.
But as
It goes
understood
both
by,
ways possibly on that.
as understood by Parliament at the time.
Certainly, as understood by Parliament at the time, yes. That it's a percent, that the words
The
amount
damages,
of the
your
payment is
point
to
is
be...
that putting, just so I understand the point, Parliament understood at the time in 2013 that a damages-based agreement was an agreement under which the what was recoverable by the funder or the solicitor or whoever it was you were looking at
Yes,
was a percentage of the damages.
yes, it was to be determined by, calculated by, reference to the damages.
And your point
It's
is that
not.
what the words is to be determined by reference to the amount of the financial benefit obtained can't mean is it merely because what the solicitor or the funder gets ultimately comes out of the damages. The source of the payment is the
Correct.
damages. it can't mean that that brings it within 3A2.
Within 3A2,
Because if
absolutely.
that were right, everything would be.
That's exactly the point.
Or that it is part of the overall calculation.
Yes,
Yeah.
The mere fact that it's there somewhere in the calculation doesn't
Doesn't
make it a
matter.
DBA.
no,
It doesn't mean that it's determined by
it doesn't
reference
mean
to-
it's determined by reference to. And
And that brings us back to what I think Lord Leggett said in Lord Sales says in 98 and 99
it does.
of PACOL.
You look to ask yourselves, what is the primary contractual entitlement?
Yeah.
Is that determined by reference to the damages? Is that primary contractual entitlement calculated by reference to damages? If it is, you're in. If it's not, you're out. A percentage of the damages is clearly calculated by reference to the damages. So you're in. A multiple is not calculated by reference to the damages at all. It's calculated by reference to the amount of funding provided. And it doesn't become calculated by reference to the damages simply because the agreement respects the fact that ultimately the source for payment is the damages. That's the position, that's how we seek to,
Well, one step further, you say if there's a cap,
or there's a cap.
it's part of the
Either.
calculation, but it's not the primary content
It's the
of the
primary
obligation.
contractual entitlement. Any other interpretation, well, and certainly the interpretation that Malone and Friends seeks to impose on the court, does immediately emasculate the respective two streams of legislation, which
Once you go broader than your analysis, Mr. Pitchinen's analysis, then you're opening Pandora's box.
you are.
That's your argument.
You don't have gaping wounds. You have irretrievable injury to the civil justice system. I say that with real force. One can't put it beyond their potential scope for argument. If it really is the case that a solicitor, which it is his case, a solicitor charging a fixed fee, says, I'm going to limit that amount of damages that are recovered. He's a DBA. He's nodding.
Well, the words read very literally by reference to are very broad. So they could capture a wide range of financing mechanisms. So it's hard to see where you would draw the line if you don't draw it at a percentage of.
Exactly.
Yeah.
Quite. That's my point in reverse. If you don't draw the line, you end up in this world where it's so broad,
Well, if everything
it captures everything else.
There's no natural limit.
Not only,
to be
there's
determined.
no natural, and it captures the very agreements which Parliament intended to be separate.
if everything which is where the source of the payment is the damages falls within the words is to be determined by reference to the amount of the financial benefit obtained, then on that hypothesis, everything, every type of pay, every type of CFA or LFA will fall within the definition of DBA.
Yes. Particularly if they've imposed caps or expressly said, I'm going to limit it to the amount of the charge, amount of the damages, which they do, because that's what they all do, because that's how we expect it to proceed. We don't want customers losing all of their damages and then being threatened with insolvency through the pursuit of claims outside that, depending on the nature of the proceedings. But the point is, Malone and Friends submissions would lead to, I mean, there are CFAs up and down the land entered into, speaking of the obvious, but this would cause such disarray. It would have profound effects on the administration of justice. Because you asked the rhetorical question, Mr. Piccini, how do you comply, Mr. Piccini, with both section 58.1 and section 58AA?
I suppose the answer is, well, that's Parliament's problem.
Well, that's what Mr. Kitchener
Well,
said.
as I say, if that is the problem, and if that is the answer, then as I say, the civil justice system is in an immediate state of array, and I don't underestimate that. It's so implausible that it can't possibly be the intention of the government. so implausible. In many senses, this is a straightforward, simple application of basic statutory interpretation. But it's because of the PACAR approach that this argument seems to have even got off the ground, with respect. That's the reality.
Heaven forbid.
Heaven forbid. The Consumer Rights
Sorry,
Act.
Mr. Bacon, forgive me, just remind me why in a sentence you can't comply with both 58AA and 58.
Well, there are different requirements in relation to both, first of all. I mean, one obvious example is you're supposed to advise clients about the suitability of either a CFA or DBA. I don't know how that works if they're all DBAs. There's obviously a statutory cap in relation to DBAs of 50%. There's a different statutory cap in relation to CFAs of 100% of the success fees. But there's no statutory cap beyond that. So you can, I mean, the doubtless a number of examples, but you immediately recognise that if you're thinking to draft an agreement, do you draft it along the lines of the DBA legislation or the CFA legislation? You can't do both. Whichever way you do it, you'll end up, because of section 58(1) and section 58AA(1), you'll end up with an agreement which is unenforceable, which is presumably what underlies the submissions that are being made.
Yeah.
Can I just then complete the history to take us to 2015, which was the introduction of the Consumer Rights Act and Section 47C. Just to pick up another point about funding, it's in the authorities bundle. In the supplemental bundle, authorities bundle, we've included the Merrick's case at first instance. So supplemental authorities bundle, tab A2. This is Merrick's before Mr. Justice Roth, the chair, and paragraphs 126 and 127 is what I was going to take you to. It's page 60 of the bundle. This was the certification hearing, and the issue was whether or not the LFA could provide for the class representative to be liable only to the extent that the CAT ultimately awarded the funder whatever it chose to award. So there's a limitation, and we had a bigger argument about whether or not the undistributed damages could be utilised by funders, and whether that was a cost that could be recoverable, and that was the issue before the tribunal, which was obviously successful. But in the course of the argument, you'll see at paragraph 126 that parliamentary debates in advance of the promulgation of section 47C were referred to. And I drew the attention to the House of Lords debate on the 3rd of November when the Parliamentary Under Secretary of State for Business and Innovation and Skills resisted a proposed backbench amendment to what became section 47C that would have prohibited the use of third-party funding in collective proceedings. Baroness Neville Rolfe stated, "We have carefully thought about this. The bill already contains restrictions on the financing of claims as it prohibits damages-based agreements and does not provide for a claimant to be able to recover any uplift in a conditional fee agreement. Therefore, there is a need for claimants to have the option of accessing third-party funding so as to allow those who do not have a large reserve of funds or those who cannot persuade a law firm to act on a pro bono to be able to bring a collective case in order to ensure redress for consumers blocking access to such funding would result in a collective action regime that is less effective. And as the tribunal observed at paragraph 127, that the government, in promoting the legislation, therefore clearly envisaged that many collective actions would be dependent on third-party funding. Now, the relevance of this is again to my learned friend's interpretation. Mr. Sauls pointed out, paragraph 127, the government, in promoting the legislation, therefore clearly envisaged that many collective actions would be dependent on third-party funding, and it is self-evident that this could not be achieved unless the class representative incurred a conditional liability for the funder's costs, which could be discharged through recovery out of the unclaimed damages. So it's again just respecting the architecture of the CAT, with the expectation that it's the damages that is the source for payment of the stakeholders. And as I was about to say, the relevance of this is to my learned friend's interpretation of section 58 AA3(2). Because on his interpretation of that provision, where a funder funds a case by reference to a multiple, so on my analysis, that's not of itself a payment determined by reference to the damages. It's and he accepts that, it's a multiple, it's got nothing to do with damages, but he says it's converted into a payment to be determined by reference to damages if the funder says, well, I'm going to respect the government's intention, the architecture of the CAT scheme by limiting my entitlement to a return to the damages, to what's available in the proceeds. And the consequence of that, if he's right about the interpretation of 58AA3A2, is that it becomes a DBA, and then because of section 47C8, it's unenforceable in the CAT. Which is another complete perversity. When the government introduced section 47, the same government introduced section 47C and outlawed the use of DBAs in opt-out cases. It understood the meaning of a DBA to be a percentage payment. Otherwise, the ban on DBAs against the desirability of funding to be utilised in opt-out cases doesn't work.
And sorry, just to be clear, when you say it doesn't work, you mean it doesn't work because it also bans CFA?
It doesn't work because the government, when incepting section 47C, recognised the importance of funding to bring those claims. So you need the funding to bring the claim. You can't have a statutory regime which bans funding in that regime.
And is this funding that you're talking about that's banned, that would be banned but wasn't supposed to be banned, funding by a CFA?
Funding by a litigation funder.
Funding by a litigation funder, which is not a CFA.
Which is not a CFA.
So we're not doing
Litigation
CFAs
funders,
at all.
litigation funders, so section 58(1) concerns those providing advocacy and litigation services.
So that's solicitors,
I'm concerned at the moment.
solicitors working under a CFA, and that's not what this is.
No, solicitors working under CFA can operate in the CAT and do operate in the CAT. They were expected to operate under conditional figurance in the CAT. They charge success fees which are deducted from the damages.
Yeah.
The issue, my lord, I'm seeking to address is the impact of my learned friend's interpretation of section 58(3)(a)(2). If it's broad enough to cover a multiple capped by reference to the damages, which is what he says it is. If it is, then such an arrangement is a DBA, and by reference to section 47C8 would be unenforceable in the CAT.
Yes. But what I don't understand is, I think you're assuming that I've understood something that I haven't, which is fine. That's why we have these discussions.
Yes.
Were there such litigation funding arrangements in place at that time? The kind that you say would be scooped up wrongly? You haven't at least, you say.
Yes, because this is part of the architecture point. The expectation that the CAT specifically operates on the basis that the class representative, in opt-out cases, the structure of the regime is that the class representative signs up to various stakeholder agreements on the understanding that it's the damages, the proceeds that are utilised to discharge the stakeholders' liability entitlements.
Right.
So,
I'm not doubting you, but where do I get that from?
well, you get it from section 47 itself. Speaks of the desirability. Well, the
Section 47C bans DBAs in opt-out proceedings.
No, it creates a collective statutory regime for the resolution of opt-out cases. It creates an opt-out case regime.
Okay.
It also bans the use of DBAs in those cases.
And your point is, which I've understood, I think, is that you're saying that what he says means that 47C bans too much. And that's your case. That's your
Well,
point.
47C, 47C8 bans DBAs.
47C8, forgive me.
Yeah, and that's too much.
Yes. And what I haven't understood is what's the too much?
It's the ability to fund the very cases which the CAT, the statutory regime, the government expected.
And where do I get that from?
Will you
Material.
Well, you get. I took you to the material in Merrick's, the fact that anything blocking any provision that blocks funding or interpretation to the statutory regime which prohibits the use of funding in the CAT will be counter the. Well, my lords.
126 of Merrick's is what you're referring
126.
to. 126 of Merrick's, which is making the point that during the parliamentary debate, there had been a proposed backbench amendment effectively to prohibit the use of third-party funding in the CAT, full stop.
Yes.
Just wouldn't be permissible. And
That was rejected.
The point that's being made by the parliamentary Under Secretary of State was that that's not what the government wanted to happen, because the government recognised that this collective proceedings, this proposed collective proceedings regime, because it was then a proposed regime, couldn't work or wouldn't if third-party funding were not available.
Correct.
And what they did ban was DBAs in the context of opt-out proceedings.
Yes.
And and your point is, well, if DBAs cover all forms of LFAs, such
They've done
as
the
Mr.
exact
Pitchin
opposite to what they intended
suggests,
to do.
then what you've ended up doing is shooting yourself in the foot, government. Wouldn't be the first time, but
So it's a
it would be
pointer.
rather surprising.
So it's a strong pointer agast the statutory interpretation of
I'm
53.
sure it's a result of me coming to the Packard party rather late in the day.
I doubt it.
The bit I haven't understood is what sort of litigation funding agreements were in place that you're talking about at the time, which you say wouldn't be a DBA, but would be a DBA on Mr. Pitchinen's construction. We're actually there. I understand that the agreements in this case now would be caught. I get that. But that, if I may say so with respect, doesn't help with statutory construction. What I'm worried about is that that's your argument, is you're saying that this DBA we've dreamt up now would be caught. Well, maybe it would, but if it wasn't the one that was in the contemplation of the legislator at the time, it doesn't help you.
Well, I'm slightly
So what I'm trying to
I understand my lord's point.
The submission you're making, Mr. Bacon, is that there is a class, and I thought it was CFAs, which is why I asked you that question, and that's what Baroness Neville-Roth refers to. She refers to CFAs, and you made the point, and I get it. It's not CFAs because LFAs, litigation partners, don't enter into CFAs. I get that. But what I haven't seen anywhere is a class of litigation funding at that time, which is in the category which you say wasn't a DBA on your construction, but would be a DBA on Mr. Pinch's construction. I have a funny feeling the answer is there aren't any. But I may be wrong, and I'm very happy to be told I'm wrong, and you can show me. But
Yes.
you haven't so far shown me a litigation funding agreement that falls into that category.
Well, I of course come from the starting position of that we are handicapped by PACCAR. My principal submission would be and remains if it's never needed to be deployed.
But isn't that the
All
point? Yeah.
funding agreements, however they are constructed, were not intended to be banned.
That's
through
the point.
s-
I mean, the point.
that's
the
the
answer
point.
to my lord's question, I think,
All of them.
is there aren't any because you say
That's the problem
right-
with PACCAR.
You say rightly or wrongly that at this time in 2015, nobody contemplated that third-party litigation funding agreements would be.
To the
damage
contrary,
based
they were to be
agreements.
encouraged.
No, but
At all.
I understand that. But if my lord will forgive me, as I understand, and tell me if I've got this wrong, but my understanding from listening to all this is that at the time that we're talking about now, which is when Section 47C8
Yes.
was brought in, litigation funding agreements were calculated by reference to a percentage of the damages.
Or multiples. There were. I mean, I can't give evidence in cases, but the
that-
market was a yes, percentages or multiples. They weren't.
Well, that's
So I don't know if we've got any evidence for that, but that is the.
you see, well, that's part of the
Well,
point.
no, with respect to, I don't think it matters.
Just a second, Mr. Bacon. If in fact, and I don't know, you're
No.
telling me that's not the case, fine, doesn't appear to be in the material anywhere. But if in fact at this time, which is whenever it was, 2015, litigation funding was done by a percentage of damages, then the problem isn't, and you can't work out what Parliament intended about that just because PACCAR happened later and decided these were all DBAs. That doesn't work. Now, if that's not true, and if in fact litigation funding was done as multiples as you're talking about, then I can see the point you're making, but I don't understand the point you're making. If in fact all litigation funding agreements were done on a percentage of damages, because if they were done on a percentage of damages, then they were DBAs on the construction of what a DBA was, but it didn't matter because they weren't claims handlers. And I know you don't like what happened in PACCAR, I understand that, but if that's the situation, you can't interpret the intention of the legislature pretending to interpret the situation was something different. That's my point.
Yes, I understand, but the answer to it is both. There were different. One answer to it may be that it's a slightly roundabout way of establishing the point, but in PACCAR, it's pretty clear that the Supreme Court proceeded on the basis they were faced with percentage agreements. They were proceeding on the basis, as I understand the judgment, as I think we all do, that there were other alternative ways of litigation funders providing litigation funding, because the statutory material points so strongly, which they would have, I'm sure which they would have had regard to, and did have regard to, certainly some folks referred to in the dissenting judgment, that in opt-out cases, litigation funding agreements, litigation funders generally were required. And if PACCAR is taken to its logical conclusion so that there's no other way of funding, so that all funding agreements are effectively percentage-based agreements, then you create an unenforceable.
No, I see.
Yeah. And the best way of seeing that is probably the position is intriguingly in the approach that's been taken to permission to appeal, because in PACCAR, permission was granted. An application was made for permission to appeal to the Court of Appeal, which was refused on the grounds that the decision wasn't statutory, wasn't an appeal falling within the statutory remit of the Section 47, because it didn't
Didn't raise a point of law.
Didn't raise a point.
No, because it was not, the language is not wholly concerned with related to the damages.
Oh, is that rather?
It's quite an odd provision.
Yeah.
Whereas in this case, the tribunal below, and as necessarily this court has accepted, that this appeal does relate to the damages because it's accepted
There's that one.
that if the appeal is successful, then there won't be a claim for damages.
I wonder if part of the answer is that there really wasn't a body of evidence upon which anybody was expressing a view in 2015, because as we all know, the market for funding didn't really develop until after the Supreme Court in Merricks, because of the CAT's fairly limited judgment first time round. And it was really in the light of the Supreme Court judgment a few years later that the market really began to take off, and we saw this large growth in collective actions. So around that period, I don't suppose there was a great deal of evidence as to what sorts of arrangements were being entered into.
No, that's probably right, but sorry. No, there weren't any opt-out cases either. So you know, it's a new breed in 2015. But my lord, I hope that's clear. Our the learned friend's interpretation, just so that my lord has it, and I say so respectfully, is that he converts any form of funding agreement beyond just a percentage into a DBA. So,
Well, he did, but it's accepted though, isn't it, by the appellants, that if there weren't a cap,
that it wouldn't be a
then
DBA.
it wouldn't be a DBA.
Correct.
So to that extent, he's not arguing that every litigation funding agreement.
But in the
is a
CAT,
DBA simply because the source of the payment is the damages.
no, but in the context of the opt-out regime, that you won't find an agreement, and there shouldn't be an agreement, it might be said, where the funder or stakeholders are not paid otherwise than from the damages.
Sorry, say
The
that
proceeds. In opt-out cases,
again? Yeah.
the whole expectation of the operation of the scheme on distribution is that it's the proceeds that are utilised to discharge the liabilities. That's why you have these distribution exercises. You don't say, "Oh, we don't need that because you can go and you can pay the funder from your, you know."
But
The flat
there's
Chelsea.
no other money in most.
There's no other money.
Opt-out cases. Yeah.
And any money that remains goes to charity. So it's quite a unique arena, which we submit must be respected when it comes to the interpreting section 47C8 when it was introduced in 2015 and referring to DBAs.
I mean, it's not an unimportant point that in any practical sense, opt-out can't work absent remuneration out of funds.
Litigation
Totally,
funding
that's
is
my
out of
point,
the
my lord.
proceeds.
That's
the
the point.
proceeds, in fact, work as a cap.
They work as a cap, exactly so. I think it's probably an appropriate moment for the break.
Should we have a 5-minute break?
All eyes in favour?
I think just probably explanatory notes, memorandums, guide. There's no evidence. But they've got
Good, yeah, it was really nice. It was
Okay, yeah, okay.
fun. We had,
See how
it was,
it's a real problem.
there was really team. So like boxing wasn't like introducing all of the like saying something nice about teachers, but all of those were really good. So they were like 6 little speeches in like 20 minutes. So that was really good.
What a people
Oh, sorry, yes, it is.
isn't it?
Yeah, it certainly is.
Thanks, Georgie. And then one of our partners, Alex, and that was research in Alison. But it's fun, but the seating plan was like James likes that, which was having his wine at the end of the table, but otherwise I'm like, so it's like all day. We're really interesting to each other. Which is actually quite nice. I don't know Arabic that well. That's really good. Yeah. Which was yeah, it's really good. Yeah, I had not heard of it either, and I don't really see it. I don't know if it used to be something different. But it's really good. Really good. So yeah, there's like quite a nice space for drinks. It's good. It's good. I drank too much as usual. I was home by midnight. It's good. No, it's totally fine. I just there were loads of paparazzi outside, so I don't know what's happening. It's just something fun. Oh yeah. I figured out who it was. Yeah, I figured out who it was, but that makes sense.
Peace is good as well.
Yeah.
Court rise in favour.
Well, can I just then turn to some of the other statutory material, the background explanatory memorandums. I know that you were taken to some of the extracts yesterday.
Yeah.
Authorities bundle, page 1362. Just to start this.
That's volume 4, is it?
That's right. It's I've got mine in 2 bundles, so it should be 1362. I think that's bundle 4. page 1362. We start with the damages-based agreement regulations 2010 explanatory memorandum. There's a reference at 7.5 which you were taken to yesterday to the representative's fee being contingent upon the success of the case and is usually determined as a percentage. I've said what I've said about what that was.
Sorry, I'm sorry, Mr.
Sorry, that's on page 1363, paragraph 7.5.
Oh, yeah.
Just usually, as I understood the point you made, Mr. Bacon, you showed us an example in which it wouldn't have been determined as a percentage of the compensation received by the claimant. It would have been determined as a percentage of the salary they received after they got back to work.
And it's probably worth digressing a moment just to go back to this statutory regime and defining what a specified financial benefit is. So we haven't focused on this, but in section 58 AA 3A1, it defines, I don't know if you've got page 27 of the authorities bundle available at the same time. Sorry to be requiring a bit of dexterous manipulation. I'm just going to focus on the words specified financial benefit and then the definition of payment in subsection 7.
Subsection.
So the way it works is that the recipient is to make, looking at 58 AA 3A 1, the recipient is to make a payment to the person providing the services if the recipient obtains a specified financial benefit in connection with the matter. Over the page, the payment in subsection 7 includes a transfer of assets or any other transfer of money's worth to a payment above a prescribed amount, or an amount calculated in a prescribed manner is to be construed accordingly. The damages-based agreement regulations go on to crystallise the definition of payment at page 64. As that part of the sum recovered in respect of the claim or damages awarded that the client agrees to pay the representative. So this is there's a very broad definition of payment in the Act, but then it's condensed into a narrower meaning through the regulations, which is what Parliament intended. Start with a wide definition, leave it to the regulations to tell us anything further. The example that my lord identified, that I identified through that footnote 9, respects the fact that specified financial benefit against which the payment is to be determined, because they are the same. If you look at 58 AA 3A 1 and 2, you have to obtain a specified financial benefit. Then the payment is to be determined by the specified financial benefit, whatever it is. And the footnote was observing that there could be a different specified financial benefit, and that was just a feature of the, but however it is calculated as a percentage of that benefit. Going forward in the 2013 regulations, the specified financial benefit has been effectively reduced because the payment is that part of the sum recovered in respect of the claim or damages awarded that the client agrees to pay the representative. That was just a short discuss into the definition of payment, but my lord is right that the word usually reflected the fact that when in 2009 the provision was introduced, it might not be a percentage of the damages, but a percentage of some other benefit that is obtained.
Specifically in the employment context.
Specifically in the employment context. And then if you, the next explanatory notes of LASPO.
Yeah.
Now my learned friend took you to this, well, no, he didn't take you to it, but he did after I asked him to do so, and no criticism, but this is important because the amendments made in 2012, which introduced the caps to success fees, which we looked at, and obviously then the subsequent 2013 regulations and the DBA regime were made at the same time, you can see that in 288, the government was proceeding on the basis that a DBA is another type of no-win, no-fee agreement, so the other one being CFAs, under which lawyer can recover a percentage of the client's damages if the case is won. There was no caveat or to the recovering of a percentage in that statement, and that again is picked up and adopted when it comes to the 2013 regulations, which I don't think the learned friend took you to, paragraph 2.1. Here it's very clear, page 1381. It's very clear that Parliament was proceeding on the basis that the payment is contingent upon the success of the case and is determined as a percentage of the compensation received by the client. And that's partly why I took you to the definition of payment, because payment is defined in the 2013 regulations as the sum, part of the sum recovered in respect to the claim or damages awarded. The part is the percentage. It's not surprising that the regulation then caps what you can recover by reference to a percentage. And then when it comes to the Consumer Rights Act 2015, the explanatory notes at page 1389, you have the section at paragraph 434 about the aim of the opt-out collective proceedings regime, which was to facilitate access to justice, to allow consumers to achieve access to redress for losses they've suffered.
Sorry, which paragraph?
Page 434 and 435. Paragraph 434 and 435, page 1391. 434 and 435, page 1391. I've already made the point that access to justice is just impossible in relation to opt-out proceedings without litigation funding. Yet on my learned friend's interpretation, litigation funding would not be permitted in opt-out cases.
How would it work in an opt-out? So you go for certification on an opt-out and the funder says, I can't do a percentage, so I'm going to do 10 times outlay. Cat says, tut tut, you can't have that. You'll have to come up with something else. It's going to be a percentage, but I can't yet tell you what it's going to be. Could be 50, could be 60. We'll have to wait and see. So you can have your funding, but you've got no guarantee as to what it will be. There is a mechanism there.
Yes.
It will be X times outlay subject to cap, yet to be determined. Would people invest on that basis?
Well, it would be...
It's a rhetorical question.
Yes, it's a most unsatisfactory premise from which to start, because there are 2 points to it. First of all, the class representative in the CAT is entitled to know.
Well, you invest upon a basis of a projected return.
Correct.
That's the degree of certainty you're entitled to.
Yes.
If it's all up in the air with the cap quite reasonably
almost
saying,
impossible
well, just
to
don't
certify.
know yet.
It's almost impossible to certify because it's part of the ingredients to certification that you understand that there's sufficient funding's in place and ability to pay
Yeah.
your own costs.
Yeah.
If I was to stand up and say,
Otherwise, the costs escalate for perhaps good reason during the litigation, and the funder says, this is beyond what I expected, and I have no idea whether I can recover it or not.
correct,
So, I think the system, I mean, it was always described as market-driven litigation and understood to be such. But that assumes certain things, including a degree of certainty as to return,
yes,
moderated by the CAT.
yes. The CAT has operated in that way since its inception. It's required parties to disclose the funding agreements, to explain to the CAT what the returns are, and
Yeah.
to scrutinise those. And if something stands out in the meta type case, then it gets sent back for revision. If not, it gets approved. In the world that the rhetorical question world, the CAT there's no point to that process. It
The
wouldn't even take
litigation
place.
system is some degree of certainty as to funding. I can't see how it can work otherwise.
And certainty on behalf of the class representative
Yeah, well,
that the liability will be
Claiming
limited to the
some.
proceeds.
yes. We know the litigation can be expensive. You need to be able to call upon your funders to fund. They need to know that if they do that, there is to be a proper return on their investment.
Correct. And the class representative needs to know that the liability the class representative has under the litigation funding agreement is limited by reference to the available proceeds.
Yes.
Yeah, in other words, that the class rep isn't expecting
Yeah.
him or herself to
I
sign
mean, it's a
additional
little bit
liability
like,
beyond the damages, otherwise people won't want to be class reps.
yeah, exactly. And it's not a public service, but it's a very much along the idea that the class representatives are signing up to personal liabilities in these cases.
No,
Extraordinary.
Yeah.
But that is the consequence. I know I've said it more than once, but that is the consequence of learner friend submissions, that as soon as this is my point about respecting the mechanism of the CAT. It's the sales point in paragraph 99. Just because the funder respects the position, the architecture of the CAT and how it works, by respecting the fact that its returns will be limited by reference to the proceeds. On the learned friends case, that automatically renders the agreement unenforceable because it becomes a DBA in the CAT. Doesn't make sense.
Yes, the system has always harnessed consumer protection to the funding market,
It has.
subject to certain exceptions. The carve out for DBAs on opt-out.
And over the page, page 1392, just before paragraph 439. It's quite interesting. In 2015, the explanatory note was referring to the damages-based agreement, the ban on them, and this goes partly to my Lord Justice Burst's question about what was being banned. A damages-based agreement is where some of the damages are paid to the legal representatives. It's talking about solicitors entering into damages-based agreements. It's not talking about funders at all. Now I know I've got PACCAR, sort of the elephant in the room, but PACCAR decided, at this point my Lord Chancellor made, that PACCAR decided that litigation funders were providing claims management services. It's not a case about section 58 3A2. So that's the statutory material. You've also got in the supplemental bundle, which again my learned friend hasn't taken me to. I'll just do so quickly. There are two there's the Competition Appeal Tribunal Guide, which is at the back of the bundle, page 170. There are two references that I wanted to draw your attention to. One we'll be familiar, which is the nature of the rules themselves, which are obviously promulgated through statutory instruments, and then the guide itself, which is intended to supplement the rules. In the guide at 6.81 on page 175, there is a description of a DBA being, quotes, in essence, the DBA provides that the fees payable by the client to its legal or other representative are determined as a percentage of the damages awarded to the client. Determined as a percentage of the damages.
Speaking, you said the guide were a statutory instrument, aren't they? Something more like a practice.
The rules are statutory instrument. The guide's more like a practice direction. 171. The requirements of the guide to the proceedings of the Competition Appeal Tribunal and any supplements constitute a practice direction issued by the President. So that's the statutory regime. But we've flagged in the skeleton that if the matter were to go further, and I'm sure it won't, so with expectations of either the court accepting my submissions or the government intervening beforehand, that we shouldn't be taken not to be reserving the right to contend that ultimately there was never an intention on the part of the government to ban litigation funding agreements in opt-out cases. Can I just turn very quickly then, before Mr. Saul deals with issues 2 and 3, the agreements, just very quickly, starting with Gutmann, I think probably by way of illustration, just to see how it works. In the supplemental bundle, the second one. Page 530 it should be. Right. Got it. Yeah. So Mr. Saul is going to deal with CICC and Neill. I'll just quickly deal with Gutmann. The litigation funding agreement is at page 500. Tab E1, I believe. I bring this to the court's attention because you're familiar with it. You've looked at it a month or so ago in the other Gutmann appeal.
Sorry, this is the Gutmann LFA.
Gutmann LFA, I was going to refer to page 503, just to make good our submissions by reference to section 58AA.
Yeah.
The funder's return is calculated in the Schedule 2, and there are two tables, one dealing with payments from distributed damages, pre-distributed damages, and others dealing with payments from undistributed damages. There are different capital returns, but you'll see in the table 1, the right-hand side, the funder's return is, and then 2.05 times capital committed, 2.55 capital committed, and table 2, again, the funder's return is expressed as that multiple return. That is not a return calculated self-evidently by reference to the damages. And the obligation of the class rep at page 504, the class rep and the solicitor shall use reasonable endeavours to obtain the court's approval to distribute the proceeds in accordance with table 1. So it's a contractual obligation to do one's best to ensure that the proceeds are utilised to discharge the liability. That is not converting the primary contractual entitlement of the return, the multiple, to a section 558A 3A2 DBA. And the waterfall arrangements at page 505 respect the fact that all proceeds will be applied in the following order. So there's an expectation implicit in the arrangements that the proceeds will be the source of payment. And that's also seen from paragraph 5.1. But all of these provisions relating to proceeds are just identifying the source for payment, ensuring that the primary contractual entitlement is satisfied by proceeds as opposed to something else. The same position can be seen in the case of Kent. Kent is page 282. Sorry, it's my fault. It's 1-1. It's one. There's an incorrect reference. It's 114. 114, I believe. And that's not right. That's CICC. 409. Sorry, it's probably. Four 409. My apologies. It's a restated amended agreement.
409.
Correct. And you'll see that the funder's fee is defined at page 421. It's defined in accordance with clause 9. And clause 9 is at page 429. And the funder's fee was initially, prior to its amendment, payable set out in accordance with the priorities deed as follows: 2 times the funder's outlay, or 2.
I'm not sure where you're reading from now.
Page 430, this was the original Kent agreement. It originally provided for 30% internal rate of... No, this is the final version.
I can see this is the final version.
454. Yes, but those clauses didn't change. Yeah.
Do we need to look at the detail of any of this? Because I think Mr. Pitchin only really took us to...
Well, my lord, just to make the point...
CICC agreement to an extent to the Neill agreement.
I just wanted to make the point that originally, you'll see, I took you to 4.2, clause 9 was at 4.2.9, and over the page 4.30, how the funder's return was calculated by reference to percentage.
Hang on a moment.
4.30. Then it was subject to amendment in November 2023.
So 430 is the unamended version.
Correct.
And that's what 9.2.2.
That is
9.2.2 had the percentage of damages.
that because of 9.2? It's because
Correct.
of 9.2.2.
Because of 9.2, the first point was an internal rate of return.
primary, well, a part of the payment
Part of the payment was
was
deferred by
always going
reference.
to be outlay, percentage of outlay.
Correct. And then the amended version
Yeah.
is at page, of that clause is at page 475. the funder's fee shall be payable as set out in the priority deed and calculated as 2 times funder's outlay or 30% of internal rate of return, and a sum equivalent to 2 times the funder's outlay. And then a further 0.5 times
Yes.
thereafter. So it's converted into a multiple. But it's calculated in that way under 9.2. That is the principle, that is the primary contractual entitlement. But as my lord has observed, plainly the expectation is that the proceeds will be utilised to discharge the liability in accordance with that calculation. And you get that from the obligations that are on the class representative in clause 3, starting at 467. And in particular at page 469, clause 3.2.12.5. Take all reasonable steps to obtain an order from the court. The class representative's full costs and expenses, other recovery costs will be paid from undistributed damages. So you're maximising the recovery of costs.
This is the cap.
Yes, this is the cap. So that's the two agreements.
It's not an express cap. It's
not an express cap.
Implicit cap because the undistributed damages will always.
As I say, it's indeed, my lord, it's respecting the architecture of the CAT and how it works in opt-out cases. Just finally, before Mr. Saul stands up, there are some points made by my learned friend in his skeleton about common ground. He says at paragraph 2 of his skeleton argument, that it's common ground paragraph 2, the common ground that the class representatives accepted the LFAs were unenforceable on the basis that they were damages-based agreements for the purpose of section 58A of the Courts Legal Services Act, and therefore unenforceable. That's not correct. There's been no acceptance in relation to opt-in cases that the LFAs were unenforceable. Mr. Saul's going to be dealing with the opt-in arrangements. But the opt-in arrangements, just so you have it, are arrangements under which the lawyers share their DBA receipts. They themselves have a DBA under the arrangements, and they share, or a CFA rather, when they share their receipts under the CFA with the funder. And where a lawyer shares their own receipts, that's not a funding agreement captured by section 58AA3. It's not a DBA. Because the payment that is paid to the lawyer is not a share of the proceeds, it's a share of the law firm's fee income. So that's point number 1. There are other points too, that it's not common ground. For example, that each of the DBAs would not be would satisfy the conditions of section 58AA. I made the point earlier about the fact that the section requires the specified financial benefit to be the same special financial benefit when it comes to calculating the payment. And what you see in some of the LFAs is the receipt of proceeds, damages being the specified financial benefit, but the funding return being calculated by reference to that plus something else, namely costs, by way of example. And so there isn't the symmetry, and that would take the case out of section 58AA3A22. So I just wanted to make those two
Sorry,
points.
that last point is
Mr. Saul's going to deal with that in the connection, I think, with the CIC.
Opt-in or opt-out?
Both. Well, opt-out, probably both. Where you don't have the symmetry, we do contend that you don't fall within 58.003. Lords, they're my submissions. Mr. Saul's going to deal with issues 2 and 3.
Okay.
Unless there's anything I can particularly assist
No,
with.
thank you very much.
Thank you.
Very good. Right.
My Lords, I'm going to deal with 3 matters. First of all, some further points of contractual interpretation relating in particular to the CICC agreements, because it is important in my submission that the court fully understands those agreements, and there are additional points which arise, in addition to those which my learned friend Mr. Fagan has made, which we adopt across the board. I should make clear that those submissions are of general application to all of the agreements on the respondent side of the court. But there are some additional particular points that arise, in particular on CICC, also in one case in relation to Kent, further reasons why the appellants are wrong. I'll take that at pace, but the agreements are complex, so I'll need to show you the definitions and work through them. And there are also similar points on the ATE agreements. And then I will deal with issues 2 and 3.
Okay.
Starting with the points on the CICC agreements, just to be completely clear about this, and I apologise if the court already has this, there are 4 claims. An opt-out claim against Mastercard, an opt-out claim against Visa, an opt-in claim against Mastercard, and an opt-in claim against Visa. Now, the claims all relate, as you will know, to alleged overcharging by the defendants in relation to interchange fees. The broad distinction between opt-out and opt-in, and this is something of a caricature, but it's the broad distinction, is the extent to which the opt-out proceedings are open to larger businesses. There's effectively a cut-off point where businesses with a turnover of more than 100 million are required to elect in positively. Smaller businesses are caught in the opt-out class. Now, that is a simplification, but it's broadly the architecture. The thinking being that the larger businesses are in a better position to decide positively whether they want to participate.
And we have a large claim.
Now, let me address first the opt-out LFAs. Now, you were shown these yesterday. Let's, again, being clear about the architecture here, there are separate LFAs for the opt-out claim against Visa and the opt-out claim against Mastercard. But they are, in substance, for our purposes, materially identical. My Lord, you asked about the history yesterday. They were originally entered into on the 7th of March 2022. 2022. Amended and restated versions were prepared in September 2023 after the decision in PAC had been handed down and before the relevant hearing before the CAT at which these funding agreements stood to be considered. Now, the amended and restated versions I've just mentioned are the versions which were before the CAT at the hearing on the 10th of November 2023, which gave rise to this appeal in the CICC proceedings. And they are the versions which are the subject of debate at this hearing. They were executed before the CAT. They are executed now. They do not include, the opt-out LFAs do not include the conditional language around percentage payments, not in the opt-out. So issues 2 and 3 do not arise in relation to the CICC opt-out arrangements. For your reference, my lords, you have the relevant agreement in your supplementary bundle, tab A4 for Visa and B4 for Mastercard.
So in other words, the issue 2 only arises in CICC opt-in.
Correct. I'll come a bit later on to the question of severance and whether or not that arises in CICC opt-in, but it doesn't arise in CICC opt-out at all. Now, I should say for completeness that the 2023 versions, which are the subject of this debate, have since been amended further in December 2024, so 6 months ago. Copies of those further amended documents were provided to Visa and Mastercard respectively on the 30th of January of this year. The parties, as I understand it, no one is suggesting that those amendments are material. And for that reason, and because those versions were not the versions before the CAT, they are not in the bundles. Now, the opt-out arrangements, and this is very important and is easy to overlook in the analysis. The opt-out arrangements are subject to priorities agreements. Again, one priorities agreement for the opt-out claim against Visa, one priorities agreement for the opt-out claim against Mastercard. Again, for our purposes, the two are materially identical. The versions in the bundles, and which are the subject of your consideration, are the original versions. They date back to August 2021. And in the bundles, again, for reference, I'm not going to them immediately, it's A3 for Visa, B3 for Mastercard in the supplementary bundle. Those are the priorities agreements that were before the CAT. They're mentioned by the CAT in its judgment, paragraph 13. Again,
So they weren't amended after PACAR?
well, you've taken the words out of my mouth, my lord. They were not amended prior to the hearing before the CAT on the 10th of November 2023. They have been amended since then, again in December 2024, in line with the most recent amendments to the opt-out LFAs. I'm telling you this for completeness so that you have the full picture. The updated versions were shared with Visa and Mastercard in January of this year. Again, no one is suggesting that those amendments make any difference.
They don't make any difference?
And they were not before the CAT, so they're not in the bundles.
No, okay.
Let me just address you now on the opt-out agreements. The funder's contractual entitlement is very, very, very far removed from anything which could be said to be determined by reference to damages. And here you do have to look at the agreements a little bit more carefully than we have done so far with respect. If I may please work from the opt-out Visa LFA for convenience, but as I say, the same points apply on the Mastercard one. Now, if we pick this up please in the supplemental bundle, tab A4, and my lords, tab A4, supplemental bundle tab A4. Now, my lords, on the speed at which I approach these submissions, I'm conscious on the opt-out, you looked at this yesterday. Equally, I'm conscious the agreements are complex. If I'm going too fast, let me know. I'm not trying to trying to race against time. But equally, I don't want to assume that you don't know a great deal when you may well have a complete mastery of these documents. Now, the funder's entitlement to be paid in this document is at clause 3.1, page 40. You looked at this yesterday. The funder is entitled to receive a payment out of the total fee in accordance with the waterfall. That is the funder's contractual entitlement in the opt-out proceedings. I know there are a number of definitions we have to traverse, but that is the clause that identifies the funder's entitlement. And you can see also, to pick up a point that my learned friend Mr. Bacon just made in the context of Kent and Gutmann, 3.2, which builds in the architecture that you find in the CAT scheme, and I have in mind Rule 93 brackets 4 and C of the Competition Act in relation to the order of a tribunal and the way in which the CAT intervenes at the distribution stage. Now, getting the Russian dolls in order here, we have proceeds, that is one concept. We have a smaller concept, which is total fee, capitalized and as a definition, and then the funder's entitlements fall within the total fee. If we now look at the definitions, and again I'm conscious you did look at these, so I'll take this relatively quickly. just by way of reminder before I make develop the points. The definitions start at page 50 here. Proceeds, and here we get into the granular, but it matters. Page 53, proceeds means the total amount of damages and costs paid by the defendants. Total amount of all damages and all costs, not undistributed. So your triggering event giving rise to a liability to pay is found there. I would also make a somewhat more presentational observation, which is that it doesn't have the immediate appearance of a damages-based agreement when the triggering event is also costs. Now, one then turns, please, to the definition of total fee in Annex 6, which again you've looked at. It's page 59 of this agreement. Total fee is made up of 4 things. Capital outlay, which again in brief is the amount invested by the funder.
It says new there. Is that because it's an amended version?
Exactly.
Yeah.
So total fee is made up of 4 components. Capital outlay, effectively in summary terms, the funder's investment. Insurer outlay, again in summary terms, the amount that the insurer has paid out so far, actual losses or similar. 3, success fees due to solicitors under CFAs. We're an opt-out here, hence the reference to a CFA. I'll come back to the opt-in. And then D, an amount equal to the capital outlay multiplied by 200%, with that percentage increasing biannually. Now, that's the multiplier, but that is not the amount, without more, that the funder is entitled to, because it is clause 3.1 in accordance with the waterfall. I would just pause here. There was effectively a point of prejudice about 14 times or something made yesterday by my learned friend. It was suggested that in these interchange cases we're in the foothills of litigation. I'm not in those cases, but my understanding is that there are umbrella proceedings which have been ongoing for a long time.
Yeah.
That in these proceedings, CICC are now part of those in colloquial language, that in fact they led in trial 3. There also have been 2 prior trials, which are likely to affect to some extent the outcome in the CICC cases. So we're not at all in the foothills of litigation. And finally, purely on the presentational point made by my learned friend, it doesn't lie well in their mouths to criticise potential high multipliers when in the same way they come before this court and say it can't be limited by reference to proceeds.
Well, there is an inconsistency there.
Well,
sure.
I won't spend more time on that point. Now, key point, moving back to the core arguments, total fee is made up of all of this. Now, what is the limit? Where do you find the limit? It is, as my learned friend said yesterday, in the final bit of the language, starting notwithstanding. Total fee shall not exceed the portion of the proceeds that have not been distributed to class members, etc.
Sorry, where did you get that?
I'm in the language at the end of Annex 6, the 3 lines at the
Oh
bottom.
yes, got you.
Total fee shall not exceed the portion of the proceeds. Now, so what is that limit? It is A, undistributed damages, but it's also B, recovered costs. Because proceeds, capital P, as referred to in that language, is all damages and costs recovered. Now the costs, by definition, will not be distributed to the class. You don't pay the costs out to the class members. They get a share of the damages. So that portion of the proceeds that have not been distributed to class members is unrecovered or undistributed damages, plus recovered costs. And that is confirmed if we turn back into the agreement at 7.4, page 44. It's there in terms. So page 44, 7.4, total liability of the class representative for the total fee shall not exceed the sum total of 1, the amount of any unclaimed damages, and 2, any costs or disbursements recovered. Now, why does that matter, my lords? It matters because, as my learned friend Mr. Bacon explained, when you're looking at whether section 58AA3A is satisfied, there are 2 requirements. And perhaps we can just turn back to it. I appreciate the court's probably memorised the sections and subsections by now, but if we could just have it open in Authorities File 1, tab 1.3, page 16, please. If we keep the agreement volume open just for the time being.
Yeah.
Now, this is the submission, my lord, the Chancellor asked a question of Mr. Bacon of, and Mr. Bacon said, well, Mr. Saul will help you. You've got to satisfy both 3A, Roman 1 and 2. The first condition in Roman 1 is that the recipient is to make a payment if the recipient obtains a specified financial benefit. So that is a concept. Secondly, the amount of that payment is to be determined by reference to the amount of the financial benefit obtained. Those 2 concepts have to be the same. It's clear in the second limb, Roman 2, that the reference to the financial benefit obtained is a cross-reference back to the specified financial benefit in limb 1. If, and this is a submission on top of all of the broad submissions, broad and detailed submissions of Mr. Bacon. But if we're going to get technical about this, as my learned opponents seek to do, well, we can get technical in response. And the answer is here that you do not, in the CICC agreements, have an identity of concept in those 2 things. Because the trigger event for payment is proceeds, all damages and costs. And even on my learned friend's best analysis, Mr. Piccinini's best analysis, the amount of the payment, and I don't accept it's determined by reference to these things at all, but even if one were to accept that premise, what is the cap? It is undistributed damages and costs. So you don't have identity of concept between those 2 things. And it's a point actually that just goes to show that these provisions that we've got in front of us here aren't trying to capture this sort of arrangement at all. It's just not the sort of agreement that these particular statutory provisions seek to capture at all.
Mr. So just to make sure I've understood your point is that the recipient doesn't obtain the costs.
No, it's a slightly different point, my lord. I'm sorry if I haven't explained it properly or sufficiently clearly. In 3A, to satisfy the requirements in 3A, 58AA 3A, you first have to have a payment which is due, where liability to pay is triggered on obtaining a specified financial benefit. In the second category, the amount has to be determined by reference to the exact same benefit.
Yeah, you said that.
In CICC, the trigger is all damages and costs, but the cap is undistributed damages and costs.
So it's nothing to do with costs.
No, it's not a costs point.
No, I see. You just made a lot of references to the costs, so I thought that
Well,
mattered.
that's the reason I did that is because it was being suggested yesterday that the cap is undistributed damages. That's not correct. So I just wanted to make sure we
But leaving costs out of account, your point is simply the point that the cap is by reference to undistributed damages, not the totality of the damages.
Exactly. So you have a disconnect between the financial benefit that is said to
Because
operate.
the
as a
overall
cap.
financial, the specified financial benefit obtained is all the damages.
Exactly.
But the
Does it depends what meant by the word obtains, what the recipient obtains? Is there a real, I mean, we're talking about two categories of damages, damages as a whole and undistributed damages.
Well, I suspect, my lord, that the question again illustrates that these provisions are not intending to capture this sort of situation at all. But the only sense I can make of this is that that language, specified financial benefit, must be the same thing in both clauses. And if the amount of the payment, if the cap, as it's being described in these proceedings, in this appeal, is a different thing to the amount which triggered, to the thing which triggers the liability to pay, then you don't have identity of concept across Lim 1 and Lim 2.
Wouldn't that apply if, for the sake of argument, if you had an agreement in which the agreement was that the payment would be 50% of the costs? Oh, sorry, not costs, forget about costs, 50% of the damages. So the damages, the total damages are the specified benefit, financial benefit, and the 50% which are paid are, on your analysis, a different thing. They're part of the damages, just as the unspecified damages, or undistributed damages are part of the damages. They're just part of the damages. I don't understand why that means when you say they have to be the same, the number going into the determination has to be the same. Yes, but that is true. That's satisfied on this, isn't it?
Well, the undistributed damages, it's very difficult to know ex ante what percentage. That I would respectfully suggest it's a different situation, because one could not know ex ante what the undistributed damages would amount to as a percentage.
I mean, just to be slightly flippant, but not really, if you had a contract which said you will get a percentage of the damages, but the percentage will be determined by rolling a dice, it would still be a damages-based agreement.
Maybe I can think about that one over lunch, rather than answering on the hit, as it were.
I mean, I think your point is a more subtle one in a sense, because it's about undistributed damages which are not. It's a moving target, really.
It is a moving target. That was my first answer to my lord, Justice
So you're not
Prowse.
determining by reference to the amount of the financial benefit obtained, because it's by reference to a completely different.
It's just a different category.
Yeah.
I mean, in my lord's 50% example, you can say, well, if the damages recovered are 5 million, it's going to be 2.5 million. It's undistributed damages. It's subject to all sorts of.
And it's not just a mathematical exercise. I mean, the rolling of the dice, I appreciate, is trying to test the point. But at least you know you're going to be between 1 and 6.
Yeah.
In this case, it's conceptually different. I appreciate it may be a subset, necessarily a subset,
Okay.
but that doesn't make it the same thing.
We had
That-
we had a complex debate in the first Lateral case as to how you classify a sum that is, once the damages have been ordered, how do you classify the sum that is then passed on to the class? It may not be based upon loss at all. It may be more or less than they deserve. It may just, and the expression distributed sum, not necessarily the same as damages. I mean, perhaps supports your argument that we're talking about two different things. One which is a very quite complicated regime, the collective action, to which DBAs don't really fit in.
Certainly not contemplating arrangements of this nature, I would respectfully submit. My lords, if I can just finish on this point, I would just note that the same point arises in the Kent case. We've developed that in our skeleton argument, but perhaps I can give you the references. And if it assists, I can take you through those documents quickly to show you. The contract is in supplemental bundle tab D2. You were just looking at this with Mr. Bacon. page 454 is where it starts. The relevant clauses are in the supplemental bundle of 474. Now here costs do come into it. Page 474, the relevant clause is success in the action. And we have there 9.1, in the event of success, the class representative assisted by her solicitors shall. So the trigger for the obligation to pay here is success, which is a defined term. If my lords keep their fingers on 474, so it's ready to go back to, but I can show you the definition of success at 466. It's paragraph 1.45.
Yeah.
And it refers in turn to an obligation on the part of the defendants to pay proceeds, capital P. Proceeds is defined at 1.38 on the same page. Total amount of damages. So to come back to my Lord Lord Justice Burse's question to me earlier about CICC, what about costs? Here costs is a distinction because proceeds is the total amount of damages. So the event triggering the liability to pay, the specified financial benefit for the purposes of 58AA3A1 is damages, all damages. Now turning back to clause 9, we see clause, which was at page 474, clause 9.1.1 contains a clause that effectively respects the architecture and the CAT, the applicant, the obligation to apply. But I'd also draw your attention to 9.1.6. Now this is, it is common ground, as I understand it, having read the appellant skeleton on this, that this is where they say the cap is to be found. Pay or procure payment of the funder's fee from stakeholder proceeds. Save that, and then you'll see the language that again reflects the statutory architecture, that the amount shall be reduced to the extent that the cap orders that it be reduced. But the cap is said to be stakeholder proceeds. Well, my lords, that is different from proceeds or damages. And I can show you that if we turn back to the definitions at page 466.
Effectively, it's undistributed damages plus costs.
Plus costs. So what we have here is a different sort of disconnect. And here maybe I can defend my emphasis on the word costs earlier on, unwitting or otherwise, which is this: the obligation to pay is triggered by success, which is in turn proceeds, which is in turn damages. The cap, the source, the limit is undistributed damages plus recovered costs. It's different.
Right. Is that a convenient moment?
That is a convenient moment, my lords, thank you.
2 o'clock.
What, rise of anyone?